will they actually decide on Monday whether it's tax or not?
Well, they won't. They won't decide. I mean, you won't know what they. I mean, you know that we won't know what the decision is for about 3 months, as we like you said. But in order to decide what they're going to discuss on Monday, if they can't move on until they decide that question. Now,
that would mean that there's a canceled Tuesday and Wednesday then.
No. See, what happens is the argument takes place, and then when that's done, they go back to their chambers. They all have their own chambers, and they all have clerks. And these are real high intelligence people from top-notch law schools, and they really write the opinions, pretty much. And then the justices, the individual justices, edit them and tells them what I want to decide, and then give me a memo on it. So that's what happens, and then they circulate those opinions to each other, and they try to get each other to sign on to their view of it. And sometimes they change. Sometimes you'll have a 6-3 that turns out to be a 5-4 the other way because a couple of people have jumped ship. So this is, everybody says it's going to be this summer, and I suppose that that's the target, but it might not. In fact, I think the prudent thing to do for the court would probably be to let this go until after the election, and then it's out of the realm somewhat of the court and politics of the court, might say. But no, you won't see anything except for the audio tapes, and I assume those are going to be can be purchased.
I'm not sure our moderator wanted to hold.
Yeah, if we could just hold the questions for a minute. We're going to have a Q&A afterwards, a panel discussion. So let's go ahead and let John finish up, and then we'll do a Q&A.
All right, I think I can actually went faster than I thought I would. Two things that I just prep you on in terms of what the issue is going to be, maybe three, is of course, you may already know, but the Interstate Commerce Clause as the power for Congress is, well, actually, let me go back, because the states obviously have powers that the federal government doesn't. So a lot of things can happen at the state level that the federal government can't do, because the federal government is supposed to be a coalition, or a real country, but a coalition of independent states leaving as much as possible to the states. I argued in the brief that I thought that although this, as Ken Kuchina says, is not a 10th Amendment case, I think the 10th Amendment should be used in interpretation. So when you interpret a statute or something, you try to interpret the whole thing as a unit, and the 10th Amendment probably should be used as an interpretive tool in interpreting the Interstate Commerce Clause. But the thing is that so like the states, they can require you to have car insurance, although while you're also actively choosing to drive a car. But that doesn't mean the federal government can do it. There is a difference. You will hear some nonsense, probably on NPR more than anyplace else, maybe on MSNBC, about whether this is an activist court. Because what they'll say is that when Congress, when the Supreme Court or the courts strike down an act of Congress as unconstitutional, our view is that it's doing its job. They'll say that's an activist court, which is the exact opposite of what I would understand. Because an activist court means changing the law or coming up with some new law on its own authority. But if the Supreme Court were to slapping down laws all day long, that would not be an activist court. That's simply upholding the Constitution and requiring the Congress to fit within the Constitution. But this will be but they interpret activist court mean anytime the courts disagree with the Congress, they call that an activist court, which to my mind is exactly the opposite of reality. But the Interstate Commerce Clause is the most extraordinary, it's the foundation of every bad thing that Congress and Washington does. Because in their view, everything is interstate commerce. And you may have heard a little bit recently about my favorite case from law school, which is now becoming more and more becoming everybody's favorite case, which is Wickard v. Filburn. where Roscoe Filburn, I just learned some more details, was from Roscoe Filburn was a Dayton, Ohio farmer who grew, I guess he had a dairy farming. He grew wheat on his own land to feed to his cows. So they never left his land. But that was interstate commerce. And that is the high watermark of absurdity that has totally perverted the Interstate Commerce Clause and paved the way for everything we don't like about the federal government is based upon this absurd overbreadth of Wickard v. Filburn of the Interstate Commerce Clause under Wickard v. Filburn, saying that you can do basically anything you want because you can always come up with some argument that if someone, like, let's go to a microbrewery, you know, they make beer on site, I buy it on site, you can argue, well, you would have bought a beer from Germany if you didn't buy it on site, so therefore it has an effect on commerce, therefore it's interstate commerce, even though it was brewed on the same premises that you drank it on. So this is becoming, and I think that we have to be prepared at some point to say, in arguing this, Wickard v. Filburn is not only wrong, but preposterous. And one thing I think is helpful to say is Wickard v. Filburn was part of the reversal by the Supreme Court under the court packing scheme. The Supreme Court was saying to the FDR's New Deal, no, 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 and then he said, okay, fine, I'm going to appoint 6 more justices to take my way, go take it from 9 to 15 justices, and I'll get my way, and then suddenly the Supreme Court started going, yes, 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 yes. Now, if you sign a contract with a gun to your head, that's not valid. That's coercion. And yet, Wickard v. Filburn and all this thing was put with a gun, the Supreme Court said. So anyway, Lopez was one of the first cases, which is the Gun Control Act, that, and I'll end with this, is kind of breathe a little bit of life back into federalism. And I was going to read that. I'm going to read here. Yeah, here's where Rehnquist says, commerce undoubtedly is traffic, but it is something more. It is intercourse. It describes the commercial intercourse between nations and parts of nations in all its branches by prescribing rules for carrying on that intercourse. And I've lost my, here, the Supreme Court struck down the gun control, under the Gun-Free School Zones Act of 1990 by saying the act neither regulates a commercial activity nor contains a requirement that the possession be connected in any way to interstate commerce. So, you know, and you think about it, most doctors, if you go to your doctor, it's not even inter-county, much less interstate. And of course, that's another thing they're going to play with. That third thing is whether are you regulating the individual decision, or are you regulating that your patient may eventually, they'll say, well, that patient may eventually show up in an emergency room. And the argument is, yeah, well, that's fine, but that's not what Congress regulates. Congress says you must buy health insurance, not speculate about, well, what happens when you actually show up at the hospital? That's a different question, but they're trying to make it the same.
Thank you, John. We're going to go ahead and do a little panel discussion here. If the three, actually, John,